circumstances of the hearing are very unfortunate, but the arbitrator was not contacted, or the special magistrate was not contacted for the purposes of attempting to obtain the continuance until apparently late in the evening, the night before. And the union was not contacted to obtain our position until Mr. Chiro had already left. It is unfortunate that the hearing had to proceed under those circumstances, but it did. And Ms. DeSimone ably represented the interests of the county during that special magistrate proceeding, armed with proposals that she and Mr. Chiro had come up with previously. There are some minor differences between the language proposed by the parties that the special magistrate addressed. I don't think that should hold up agreement on a grievance procedure. I have not flashback to the new language in order to find out to what extent it may still exist. But we would refer the commissioners to the issue that was then presented to the special magistrate and compare it with where we are now, so that you can be satisfied that the positions are indeed resolvable.
Going to take tab F and G together, please, since they both concern discipline. And our position is the same with respect to both. That issues regarding discipline be excluded from the collective bargaining agreement. That is a right that we have as the county to request. And if you read the language that starts tab F at line 182, this is a quotation from a ruling in the above referenced case. We have the right to request it be excluded from the collective bargaining agreement, and correspondingly, the union does not possess the right to compel inclusion of discipline in the collective bargaining agreement. Let me tell you what happens when it's not in here. It defaults to what has always been your process for dealing with discipline, and that is employees have a right under the career service rules and regulations to challenge discipline. They end up with your personnel board, who conducts a hearing and makes a recommendation to the county administrator. My understanding, and others, or Michelle, Mr. Gallagher could weigh in on this, that process has worked efficiently. You don't end up paying an arbitrator to deal with the disciplinary item. The special magistrate, who was also an arbitrator with his resume, could give you a little bit of insight into what it could cost to conduct a one-day arbitration. This one-day special magistrate proceeding costs, I believe, $12,000. So you could spend a lot of money on discipline, or the personnel board represents a very efficient way of dealing with it. And I think Mr. Gallagher's track record will show that, if not universally, in most cases, he has followed the recommendations from the personnel board. This is a quick and easy and efficient way of dealing with it. We have no history with this bargaining unit in the Teamsters. We don't know to what extent they're able to work out disciplinary problems with the county administration. Time will tell, and perhaps in the future, in another round of negotiation, there might be a different proposal on how to resolve discipline. But for right now, let's keep the status quo. That's the basis of our proposal.
A key difference between the situation Mr. Chiro pointed out I am familiar with regard to exclusion of discipline from the grievance procedure, was based on the premise that there was no discipline language at all within the collective bargaining agreement. Here there is, even under the county's proposal. And the statute is clear. Once it's in the contract, you have to have a grievance procedure available, and the Supreme Court has resolved it as an alternative to be used at the discretion or the option of the employee to whatever existing system there may be. The one-day hearing in this case is obviously deceptive. It was much longer than one day because of the briefing and the study and the preparation and the writing time, all of which are part of any process, judicial or grievance, or in this case administrative, before the special magistrate. So it's not as if he came down for one day, charged $12,000, and that was the end of it. In fact, the special magistrate, based on the intimation that he was recommending in favor of the union's position not to exclude discipline because he was biased and wanted to make money for himself, wrote a rather scathing letter to Mr. Chera and to Perk. It is available if you wish to see it. I don't know that it makes any difference. The point of the exercise being that it is a misleading statement. In addition to that, the union's proposal would have stopped any further progress in the grievance procedure of disciplinary disputes less than suspension or demotion before it ever got to arbitration. And you will see that later on when you take a look at the special magistrate's recommendation in that regard. And not only that, the legislature has statutorily required that there be a grievance procedure. So you have the same expense if we're arguing over contract disputes. But the legislature has said, folks, you got to do it because it's cheap in the long run. Why is it cheap in the long run? It helps keep the relationship stable. Everybody knows the rules of the road when a neutral is brought in with an objective eye, hears the arguments, and makes a decision, just like you folks are going to do today. And for that reason, we have proposed and continue to propose that the employee be given the option of using even a contracts grievance procedure or your existing personnel board procedure for resolution of grievances. And we take the position that to impose an exclusion is indeed a permissive subject of bargaining. And perhaps Jim isn't old enough to remember this, but the Florida 3rd DCA back in the 70s said just that. And the Supreme Court has said just that in the city of Castleberry case in the Central Florida PBA, which I also litigated in 1986, as did the first DCA in Tallahassee when that issue was placed before. We don't want to litigate that issue with you either. We're trying to reach an agreement which simply provides a choice. Put it into place, let it be test-driven to see whether or not there are any real problems that might be addressed in tweaking the procedure at a later point in time. But to provoke the type of dispute that Jim is asking you to provoke, unfortunately doesn't do anything to stabilize the bargaining relationship which we are now attempting to arrive at.
Madam Chair,
Yes, Commissioner
Mr. Spencer, with the packet we got on line 185, on this it says the statute allows the board to impose such provision, 447.434D. Is what Mr. Chair said, we don't have to include it if we choose not to.
What you have in your packet at that line is a quote from the second DCA case of Board of County Commissioners of Sarasota County versus Citrus Cannery Food Processing and Allied Workers and Helpers Local Union of 173. So that's what the second DCA, this is an accurate quote of what the second DCA said.
Okay, it was done in 1998, so it's fairly recent as well.
Yeah.
Thank you.
H. This article, leave time excluded, by the way, is redundant in the sense it's also the same concept is included.
Wait, can you just wait until I get this?
Yeah,
Just leave time. Yeah.
tab H, line 190. It's redundant in the sense that if you were to go to tab J for just a moment, which deals with work schedule and overtime, down on line 248, line 248, there is also the statement that hours actually worked, only hours actually worked count in determining overtime status. The concept is the same. We started off in the bargaining process of having a separate article to deal with leave time excluded because it was a very important monetary issue from the county point of view. Let me explain what this means. I'll use a standard work week, 5-day work week, 40 hours of time, 8 hours a day. If an employee is on paid leave, on vacation, on Monday through Thursday, but works on Friday, and on Friday they work 10 hours rather than their usual 8. Absent this language, you would pay them 2 hours of overtime. Because Monday through Thursday would count as time worked, even though the employee would only have worked 10 hours Monday through Friday. The Fair Labor Standards Act has a provision that says that essentially this, that only hours actually worked need be counted towards the calculation of overtime. That doesn't mean that you can't allow other time to. It just means that under the Fair Labor Standards Act, the federal regulations regarding the calculation of overtime, that you need not include it. And that's what our proposal tracks. So on the Friday that the employee works 10 hours, they would be paid 10 hours of time, straight time. They wouldn't be paid 8 at straight and 2 at overtime. That's true if it's leave for vacation, whatever the paid leave would be. None of it counts towards the calculation of overtime. And that's repeated again, as I noted in our wage limit.
Okay.
I would like to read to you your current policy. Holiday leave, annual leave, funeral leave, military leave, storm leave, and court leave will be considered for the purpose of computing overtime compensation for non-exempt hourly employees and emergency services department shift personnel. They want to take away for bargaining unit employees only, without changing the policy, something that they currently have. We don't think it's fair.
With your permission, I should respond to that. That's accurate. We do want to change what your past practice has been with respect to including time not worked towards the calculation of overtime. If we could have changed the career service rules and regulations to accomplish that, we probably would have done that. But the law in Florida is we can't change that while we're bargaining their first contract. The only way we could change it is by negotiating with them, even if we have to do it through the impasse process, to effectuate that change. That's a change that you will see with respect to all your other county employees as we get going. But there's always a starting point to change. This contract afforded the opportunity for a first step in making that change countywide. Article, tab I, employee performance evaluation. This is a modified proposal that we've made. One of the things that the union asked for that we thought about and we did agree to, although not in a bargaining session, but in drafting this language is, if an employee were promoted, the union asked that we would adjust the evaluation date to the date of promotion so that the next evaluation would be a year from the date of promotion, rather than working from the anniversary date that occurred before the original hire date. also wanted to have the ability to grieve performance evaluations. I think you can imagine that if you have 1,000 employees and they're all able to challenge their performance evaluation, that you're going to have a tremendous administrative burden and cost associated with being able to grieve that. And there are, I can't think of any public employers where that is a possibility, where you can grieve a performance evaluation. What we've done is, if you look at line 204, is we have emphasized that you can't grieve or appeal it, but you can do some other things. An employee that doesn't like their evaluation, who thinks that it was influenced by discriminatory bias on the part of the evaluator, can request that the personnel director intervene and evaluate whether the performance evaluation was done properly or not. I think Barbara could tell you in the past that she has had the opportunity to weigh in on performance evaluations. So that is a past practice, if you will, an existing condition. And in all cases, paragraph 2 at line 210, in all cases, an employee that disagrees with their evaluation can submit their own rebuttal to it, and that document would be attached to the performance evaluation. So anybody else that wanted to look at it would not just see the county evaluation, but would see the employee rebuttal. I would urge you not to go in the direction that the union wants to go on this one, because I think this would create a significant administrative burden and a significant cost over time.
If I may have a moment, I'm still in the process of comparing this new proposal with what went before, and if I just may have my time. This is one of the bads that the union accepted that came out of the special magistrate process. The special magistrate said, go ahead, and he recommended adoption of the county's position. The only thing that I might mention is with regard to the criteria that are used. We understand that those are management prerogatives to establish standards for performance. Our problem is that sometimes standards are not fair, objective, or reasonable. And that was our only real problem with the current proposal. But that, of course, can be worked out as we go forward. And in the spirit of compromise, we will accept the county's current proposal.
Tab J, hours of work and overtime. A couple of things to point out here. Unpaid lunch, county proposal. That lunch breaks are unpaid and scheduled at the discretion of the department division director. The importance of providing discretion to the department division director again goes back to the wide range of this bargaining unit. It would be difficult to have uniform lunch breaks on a countywide basis. People working in the library, offices, out in the field, it's the directors are in a better position to figure out when the break can be taken, when it's safe to take it, when it can be taken, when it doesn't interfere with the project. So our proposal does include what is actually the status quo right now, that discretion on the part of the department division director. With respect to paid personal breaks, again, at the discretion of the department division director, they're the only individuals that can evaluate when it's appropriate to take the break. And it would be not to exceed a total of 30 minutes per day. I've already talked earlier about the overtime provision. The example that I gave is at the bottom of the page with respect to that. Top of the next page, line 255. This is an important provision. This is one that I would concede that management in some places could abuse, but I'll tell you why I don't think that would be the case here. We're talking about the ability to flex an employee's work schedule so that the employee does not accrue more than 40 hours in a work week. You budget with some buffer for 40 hours per work week. We anticipate that that's what we'll spend on a weekly basis. So the example is that if on Monday, I'll use the 5-day work week again, the employee is required to work 10 hours on Monday, they would be on pace by the time they got to Friday to work 42 hours. You pay 40 at regular pay and 2 at overtime pay. What we are seeking is the ability to flex that employee's time and say to them, when they work on Monday, you could come in an hour late tomorrow and on Wednesday. Or on Wednesday, you could say to them, on Friday, you could leave 2 hours early. The employee still gets their full 40 hours of pay that they anticipate. They've given back 2 hours that we took away from them that they might use for family or social activity. And you save the money that you would otherwise have to spend for overtime. It seems to us to be a win all the way around. I understand the union's suspicion is that we would abuse this process, that you would find that in every week somebody is being asked to work more on one day and then relieved of duty on the next, and therefore we would be beating them out of overtime. But the process that we've examined for doing it and monitoring it, I think would ensure at an operational level that division directors and department heads be instructed carefully on how to do this, and use it on a limited basis and not use it for cost savings in any way.
Once again, if I may have a moment to compare with what has gone before, I would appreciate that.
Sure.
The primary things that the union is concerned with regard to work schedule of overtime are number one, the break issue. What happens, as we pointed out at the hearing, is that whether people actually get any breaks is sporadic. They are required to work through breaks. Employee and supervisors say you can't have one today, I need you to do whatever it is that we're doing. And they're not paid for anything additional for the time that has been taken away from them. We did not think that was right, and so the special magistrate adopted our recommendation to provide for 2 15-minute breaks during the course of a workday and for an unpaid half-hour lunch break. And if the employee is required to work through them, to get paid. That's as simple as that.
Commissioner Lyon? Yeah, so basically, our employees work an 8-hour day and get an hour lunch. So
Or a
now-
half-hour lunch, I think. if I'm not
It
mistaken.
depends on the department.
Yeah.
Oh, I thought they got an hour. So I'm just trying to figure out, so is their day elongated? I mean, they're still going to be paid for 8 hours, but then you want in addition to 15-minute break? I'm not quite sure.
No. The problem is that breaks may be given under current policy. However, the employee who works during a break, in effect, works 15 minutes longer than the 8 hours an employee who receives a break works. That's the problem. And if they're required to work through lunch, that employee has in effect worked an additional hour without being paid for it. That is the issue that the special magistrate addressed, and that is the context in which it was addressed, and in which he recommended adoption of our proposal, which we thought was fair. It basically standardizes things at a minimum. You retain flexibility above that. And certainly when the schedule breaks, you always retain that flexibility. But if you're going to require somebody to work through a break, all our proposal says you have that flexibility too. Just got to pay them for it, that's all.
With regards to,
Excuse me, Mr. Pilichek, I just need to clarify, if they work through lunch, they get paid for it. That's a misstatement.
Then our proposal is satisfactory to you in that respect. And I'm happy to hear that. The second broader issue is the overtime issue. Basically, it's your prerogative to assign, it's your prerogative to schedule, all of that we talked about before. The one problem is that what can and does happen, and this was discussed at the special magistrate hearing, is that people are picked and chosen who are willing to work overtime, which means some folks have an opportunity and others do not. And that's significant to them in these tough times. Our proposal would have provided for rotation of overtime by seniority. You know, you start with the senior guy first one time, next time you go to the next guy, etc. And it was just that easy, but the county has resisted that. With regard to a flex schedule, there is inherently a problem with that, and you have to consider the employee's point of view. On a Monday, I'm scheduled to work 2 hours. On a Tuesday, I'm scheduled to work 12 hours. The problem is that there is no consistency in an employee's expected work life. And that creates a potential issue with a flex schedule. What if the employee wants to flex the schedule and that person has a doctor's appointment and cannot do so? There has to be at least some restraint on the unbridled ability to change an employee's schedule, perhaps on a daily basis, at will. And that's all we are asking for when you consider the parties' respective positions in that respect.
Ms. Mon, do we have a lot of people on flex schedule? I mean, I'm trying to figure this out.
Flex schedule, in this case, what we're talking about is flexing it to make the work week 40 hours so that we're not paying, to cut back on overtime as a cost savings. We also have flex schedules where it's the employee's request, at the employee's request, because they have a doctor's appointment, instead of using their annual leave, they work extra time the rest of the week to make it up. And that's an agreement, as long as it's okay with management. And that's worked out well. That's a win-win for the employees. Yeah.
yeah, that's why I referred to it earlier, as I thought it was a created balance, and there's times when an employee needs to flex their time.
Sure.
County accommodates that. There's times where for budgetary purposes, the county might not need, the county might need to. And I think that as we go into the next year of bargaining, if employees find that their time is being flexed at an increasing rate, that's something that they could bring back to the table.
Let me ask you another question. What about rotation of overtime?
You know, my recollection is different about what occurred at the bargaining table on that. And my recollection was is that what the union wanted was is that the most senior employees would always be offered the overtime first. That there would not be what we would refer to as a rotation wheel where that would occur. But no matter what's more important with respect to getting the work done is for the supervisor to make a determination employee can most efficiently get that work done if it has to be done with overtime?
Well, the only thing is that, I think people all should have a chance. I mean, if we hire them and they're in a position, they should be able to do the job. So why shouldn't they get a chance to do?
It certainly makes
But-
sense, and that's why many contracts do have a rotation of
Rotation, that's what
provision.
I'm saying, not the senior person, but rotation, is that,
Yes, not always the most senior.
so that's in the union.
Maybe that's a change in their position today.
It was not. That was presented to and decided by the special magistrate.
You agree?
We proposed the rotation.
Madam Chair,
Yes.
with all due respect, on page 31 of the proposal, it says, short-term company offers employees who typically perform the job function of the assignment as slave program on the basis of seniority within the Department of Work Groups provided such employees are capable of performing the work. That's the union proposal.
It's not rotation.
I can't speak to what occurred at the hearing, as I said. At the bargaining table, my understanding was that the most senior employee would always first be offered the overtime. And we rejected it.
Yeah, that was my recollection too.
I see.
On page 37, the magistrate notes, the union noted at the impasse hearing, it is amenable to assigning overtime on a rotational basis to preclude senior employees from hogging all the overtime opportunities.
Okay. Well, it's hard for us to read every single line. Okay, so you are in favor of 37. Okay.
Just to comment on the paid personal breaks. I think you could see the administrative challenge of an employee who keeps their own records about when their break started or ended and possibly exposes the administration to an additional 4.5 paid hours of work that are not budgeted for. Because that's how, at 30 minutes per day, you can end up with 2.5 hours of additional pay during the work week, all under the concept of really, when did my break start, when did my break end? It's paid right now. We pay them. We pay them in totality. So if some of them, for whatever reason on a given day, are not permitted to take a break over time, we believe that will balance out. Let's work to tab K. Personnel reduction. You'll recognize this. This is a board-approved reduction in the workforce layoff matrix, where you take into consideration a number of factors: seniority, performance, disciplinary action, additional skills training, and veterans preference. What you're searching for is to retain the employees that, based upon the calculations under this matrix, are proven to be your best employees. These are the ones that you're using your taxpayer money. You should keep the best, and the people that don't score as high are the ones that should be laid off. Certainly, I think the union mantra is going to be seniority. A lot of union contracts, I'm sure you're aware of this, provide that seniority is always protects the most senior employee, whether they're performers, whether they have disciplinary problems, anything of that nature. This is a step away from that old tradition of that seniority trumps everything. We don't think that's a good business practice. That's what this proposal reflects, because that's what this proposal is based on. The board's previous determination that seniority shall not always be the determining factor.
Management has the right to evaluate the performance of its employees. It has the right to discipline its employees if they do not perform. It has the right attempt to improve the performance of employees that management does not find satisfactory, and if such performance does not improve, management has the right to terminate those employees. If an employee has been here 30 years and can do the job to the satisfaction of management, there's no question about ability to do the job, then there is no reason why somebody who has been here 1 week should be retained, and that 30-year employee should find himself out of a job. And not only that, if the employee does find himself out of a job, he may have to reapply for available lesser positions as a brand new employee and be considered for employment. That is the basis for the union's proposal. It's not to protect deadwood. That's the mantra of management everywhere. We want flexibility to decide who's good and who's bad. We have that flexibility now. And if somebody has been there, is on the payroll, can do the job to management's satisfaction, that person should have some protection when times get tough. So that someone who has devoted a large chunk of his life to this county should not find himself on the street while someone who just arrived, maybe a whiz kid, in effect, has a job. That is why the union has proposed that seniority rule in the case of layoff and recall. We have also asked for it in the case of such things as assignment of benefits, work assignments, etc. The special magistrate recommended a committee be set up during the first contract to study all of that. And that's fine. That's one of the bads. We didn't get what we asked for, that we were willing to accept. But in the cases of layoff and recall, which are of vital concern to the lives of people and their families, your employees who are citizens of this county, we believe that fairness provides that if the employee can do the job, unless the management can demonstrate that he can't, that person should be retained if he is senior to someone who is otherwise going to keep his job.
What is this committee going to study? You said.
Seniority and other potential areas. Let me give you an example. New vehicles come in. There's 3. There's 5 people on a crew. Who gets them? You know, that sort of stuff. These are workaday type things.
So that-
But the big issue is layoff and recall.
Seniority.
What do we have? Seniority.
So our proposal provides that seniority is determined by the employee's date of hire as either a full or a part-time employee. Maybe somebody started part-time and 2 years later got a full-time position. We want to give them credit for that time. And then a provision regarding how seniority may be broken. I don't think the union takes issue with those categories. At least I don't recall them taking issue with it during the bargaining process. At line 370 through 374, we emphasize several points. One is that seniority really only has a role in the county's retention matrix. And finally, that if there is a reduction in the workforce, that by virtue of seniority, there are no bumping rights, meaning that if you are targeted and you are notified that you're going to be laid off, you don't have the right to search around the county for somebody in the same position that you are in that may have less time and grade and bump that individual. This was never an issue for management anywhere really until the last 5 years when local government started to get involved, caught up in the economy, reduced property value, and so forth and so on, and started to actually apply their layoff rules. And what we've learned is that bumping lines are a tremendous disruption to an organization. By way of example, let's just take a clerk that has 15 years' experience in one department, but is in a position because of bumping rights to be able to bump a clerk equal in all other regards with only 13 years that has worked for a department head in another division on the other side of the county. Just imagine if that bumping were to occur, the disruption to the department head who has enjoyed that clerk for 13 years. That's actually happened in local government where the bumping provision has taken effect. You know, where you thought you had isolated a division or a department to effectuate layoffs, you suddenly find that that spreads its way through the entire organization and ends up disrupting many different departments. That's why we emphasize that there are no bumping rights related to a seniority.
In the spirit of compromise, we will agree to the county's position on bumping rights. Unfortunately, that doesn't end the inquiry. In the county's proposal regarding seniority, it makes reference to the retention matrix, which we talked about briefly before. It really doesn't take seniority into much account at all, which is why we're asking that if the person's otherwise qualified to do the job, that seniority rule. What is unexpressed so far, what was expressed at the hearing, was that in a prior layoff, in fact, up to the development of the retention matrix, the county's policy was that layoffs were to be in inverse order of seniority. And in that instance, Ms. DeSimone told Special Magistrate and us that the county had no issues with the quality of the people that it had retained using that system. And that is why we have a problem with that. That is, I think, our only problem with the seniority provision that management now proposes, since we have agreed to management position on making no reference to bumping rights or permitting bumping rights outside of the department.
Oh, yeah, I'm sorry.
Yeah, thank you. Chairman?
Holidays. This is different than our proposal, both at bargaining and during the special magistrate proceeding. And what we were originally trying to accomplish, you may recall this, is that we had a fixed dollar amount that a holiday was worth $100, and that every employee that was entitled to holiday pay received that amount. What we've reverted to in our proposal now is what really is the status quo. If you're employed, you get paid your regular work day amount as your holiday pay. If you work on a holiday, you're paid premium time and a half for the hours actually worked. If you don't work the holiday, you get your holiday pay. And this is the current process that the county has been using for a number of years. It is a change in our position. It is an attempt to find compromise on that, on this provision through this new proposal.
The status quo to which the county has agreed is all the union asked for at the hearing. And that is what the magistrate recommended, and we now accept it.
Okay, wages and salary. You've just been through your budget process, so ordinarily at this point I might talk at length about the budget and the appropriations that were made for wages, but it should be fresh in your mind. You made no appropriation for base wage increases for this current fiscal year that began yesterday, and that is where our proposal reflects. There will be no wage or salary adjustments for the term of the agreement. Now that doesn't include salary adjustments if somebody's promoted or reclassified. They would get those, or actually even if they were demoted, there would be an adjustment as well. We're talking about base increases here. The rest of the language that is in this article is the status quo.
We would respectfully refer the commissioners to special magistrate report starting at page 40 and continuing to page 43. First of all, we have a problem with contractual imposition of a wage freeze. That deprives you from deciding during the term of the contract that you're going to give one. And not only that, given when it does give one to other folks, but not the bargaining unit people, it deprives the union of the opportunity to bargain over the change in conditions, which is a waiver of a statutory right, which in turn is a permissive subject. We don't think we need to impose a contractual wage freeze, whatever you decide, whether or not wage or bonus increase should be granted, and I'll get into that momentarily in any event. The special magistrate, after consideration of your financial condition, and you had somebody testify there, I believe it was Mr. Nuremberg, and he brought documents with him. And in those documents, there appeared a $200 and some million fund, general fund, which was unallocated for specific purposes. Based on that information, and considering the fact that your folks have not received a wage increase for 4 years, and I know times have been tough for everybody, although the firefighters have had an interim increase, we understand. The special magistrate determined that even if you wish to avoid a recurring expenditure by imposing an increase which now forms a new higher base rate that we're going to pay going forward. Nevertheless, the employees who have now had to pay 3% of their own money for pensions, who are effectively working for less as the result, should receive a bonus, a one-time bonus, in the amount of 3%. That is what we suggested as an alternative, and that is what we request the Commission do. What that does is relegate the subject of wage increases going forward to subsequent bargaining cycles. We can see whether or not conditions are improving. We can see whether or not the county's financial position improves. And we can address those things on a dynamic basis as opposed to freezing them into this contract. And in the meantime, the employees have received something that is designed to offset the higher cost of living we have all encountered and the loss of 3% income that they have had to suffer. So we would respectfully request that you implement that recommendation if you decide not to implement an across-the-board wage increase. We have also asked for what's called a Me Too provision.
Oh, what?
Me too.
Me Too.
Okay.
What that means is that if the county decides it's going to give other groups of employees wage increases during the life of the bargaining agreement, that we get the same increase. That way, what we have is a situation where you go ahead and give managers 5%. If that's what you wish to do, we think the bargaining unit folks, who hurt just as bad as the managers do, should also get 5%. That's only fair. So that's why we have asked for that Me Too provision as part of our proposal.
I have a question. you're saying, the very end of the second paragraph. Reference to your work's testimony, union notes it requested a 3% increase, which cost the county $1,135,000.
That was an extrapolation that we made based on certain assumptions that were discussed at the hearing.
And so you're talking,
Let's take an example. A 3% increase for a $20,000 a year employee would be $600 a year.
so,
So what we try to do is get some kind of a median, taking into account the composition of your workforce, and that's what we work from.
but you're talking about not 3% across the board, but a 3% bonus, or are you talking?
It's an alternative.
As an alternative,
Yes, ma'am.
right,
If you decide that you don't want to give an across-the-board increase because you're concerned about the recurring effect this might have going forward, and you want to save that for a later time, then at least give these folks a one-time bonus of 3%.
Thank you. Emergency clause?
Well, maybe I should step away from the microphone for a second and ask either Michelle or Barbara to talk about this. I'll just make this introductory comment.
Okay.
How to deal with emergency closure issues is a very, very difficult issue for both operational purposes, making sure that you are here collectively, and the employees are here collectively to perform the services that the public expects you to perform. But there's also wage issues regarding it. Some money that you spend in overtime during a hurricane cleanup, you recover from FEMA, some you don't. There's been an evolution of this article over time as each incident has occurred. You're flooding from the summer, gives you more insight into what to do with it. And I'll let one of them tell you how they tackle that.
Thank you, Chairman. Just so,
Yeah, I'll tackle this. So this is a change from past practice because the Federal Emergency Management Agency has changed their policy
right.
and the implications that has for the county's budget. In the past, I would say prior to 2005, if there was a declared emergency and we sent employees home, any costs that we incurred related to overtime expense were recoverable if we received a disaster declaration. If we don't get a disaster declaration, we don't recover at all. In 2005, the Federal Emergency Management Agency, following Hurricane Katrina, said the public has an expectation that public safety employees will work during an emergency, and therefore they would not reimburse local governments for the cost of overtime for those employees to be working. So we have struggled. We've had a lot of conversations, and we have struggled with how to craft this so that it is reasonable and practical in terms of its application. In our debates, we've had conversations about what would the citizen expect. So if a wastewater treatment plant operator was already scheduled to work that day and the county closed, would it be reasonable to expect that we would still pay that employee their normally scheduled hours and their pay? Yes, it is. Would it be reasonable to say that just because we sent non-mission essential employees home to pay that employee overtime, even though he was working when he was already scheduled? Maybe not so much. So what we have crafted here is language that says there are mission essential employees and there are non-mission essential employees. Mission essential, all employees are expected to work in an emergency, but if the county closes, the mission essential employees are expected to work, and they will be compensated for the hours worked based to the Fair Labor Standards Act. So if they work just their normal scheduled shift, they would receive their regular pay. If they worked extra hours or they were called back for an extra shift, they would receive premium pay for that work. What we also said was sometimes we have a situation where we have to close government offices.
Sure.
And when we close government offices, that should not automatically trigger everybody else working and receiving overtime pay. And so that's one of the things that is a change here. They would get paid if they were regularly scheduled to work. And this is very confusing. The other piece of that is that sometimes we have to close government offices to the public, but our employees could potentially come to work. And we've experienced that this summer. Right. And so if we determine that it is unsafe for employees to come to work and we order them to remain at home, then we would pay them for their normal working hours. But if we close government offices to the public, but it's still okay for employees to come to work, then they would be expected to report to work. They would be expected to accept assignment to an additional duty, hurricane shelter, resident information center, etc. And if they work, they would be compensated for the hours worked according to the Fair Labor Standards Act. And if they decline to come to work and we ask them to do so, they would be asked to take leave or leave without pay.
Did I explain that clearly enough?
She did a great job.
Yes.
We accept the explanation
Okay, short and sweet.
in the spirit of compromise, and we understand your motivation for doing that. And first time we heard it is today, and we're happy that we heard it.
I just have a question. I'm backing up to wages and salaries. When you talked about, I know that in certain instances in some other counties, they're giving everybody the same, like everybody gets $1,000 or $1,500 bonus.
Right.
Because if you go to people with higher salaries, that could 3% tax, a lot of money. So is the union amenable to anything like that, or is it the 3% you're saying?
No, we are amenable to what you believe is reasonable, but we believe there should be something.
Thank you. That concludes the impasse issues. I do have people that are signed up for public comment. So I will go in the order in which they signed up, and when you come forward, you will give your name and address for the record, and everybody will be given 3 minutes. And Mr. Edward Sidak.
Morning, Commissioners. Ted Cizik, I live at 17835 Greensboro Street. I've been a resident of Pasco County for 25 years. I also worked for Pasco County Utilities as a civil engineering technician for 10.5 years. So I do love Pasco County. I came to work here because of my background. I wanted to use it for the citizens of Pasco County. As we know, there have been some issues. Pasco County employees, we voted for a union 2 years ago, back in August 2010. And we've had negotiations that have stalled, as we've all discussed. We've heard today that many of the issues have been unresolved. We're hoping to get that done today. What we're asking as workers of Pasco County is that you commissioners really look at what the special magistrate has said. And he has brought up many good points that the state statutes and the laws of Florida really are for workers' rights. And that's what we're looking for. Your views on those and to implement the things that the special magistrate has recommended. It's been 2 years. We've had all these negotiations. It's been frustrating. We go in there, we're getting the number down. But for 2 years, we started back 2010, we voted for a union. We didn't start negotiating until January, I think it was the 28th of 2011.
Right.
So I have an article here, I'm going to speed read it to get through it. It's not real long, but it was written by the St. Pete Times. And it's kind of like a prophecy of what happened when we started out and where we ended up. It actually has taken place. I'll be real quick. Union protests over contract talks. About 60 members of the Teamsters union that represent most county workers protested Wednesday in front of the West Pasco Government Center, arguing county officials are using stalling tactics as they negotiate an initial contract with the union. Officials held 4 negotiation sessions with the union and have scheduled 2 more in June. But union negotiator John Schulke said the county is dragging its feet. Workers voted to join the union in September.
and the two sides have yet to make progress on many issues. He acknowledged the tight budget and said the union's big issue isn't pay. Rather, he said the union wants seniority protection to prevent favoritism, such as giving good jobs to people who happen to be a friend of a friend. Stuff like that means the world to these workers, he said. Goes on, County Personnel Director Barbara G. Simone said that she is focused on the quality of the contract, not on passing one quickly. She suspected the union is upset because it cannot begin collecting dues until a contract is signed. Sure. We're not going to just agree to things just to say that they can start collecting dues, she said. Negotiations are scheduled for June 8th and the 23rd. And as we know, these things are going to be decided by a special magistrate and yourself.
Thank you.
Our next employee then,
Sir, your time is up. I have a number of other.
okay, and that's going to be Doug Pike.
Thank you. Douglas Michael. Thank you.
It's Ed, and I live at 112 Bassford Lane, Holiday, Florida. That's okay, no problem. I've worked for the county for 24 and a half years now. 23 and a half in Parks and Rec, and just barely one in utilities. I started out as a groundskeeper in Parks and Rec, was promoted to a crew leader, was promoted to a park operator 1, where I supervised Ingle Park. I was asked by my supervisor to go to the Land O'Lakes Rec Center because in New York I had parks construction experience and oversaw the construction of the Land O'Lakes Rec Center for the county. I then supervised it for 17 years. And then I went to Mitchell Park, I'm sorry, as a park operator. Last year, my director held a meeting and said that my title was being cut from the budget, but that I had plenty of opportunity to apply for those jobs within the department. I applied for a crew leader at Ingle Park, which I supervised, and I applied for a off-the-street, a park attendant 2 position at the Land O'Lakes Rec Center, which is, you don't need any experience for. I was told I was not qualified for either of those positions and handed my pay slip. Last year, the Parks Department